Good morning.
Hello. Wow.
I'm Michael Abro. I am the admission recruiter and alumni coordinator here at the Charleston School of Law. Welcome, everyone. If you received an email from Michael Abro and was wondering who he is, I am him. So good morning and welcome. I am not going to spend much time up here today. I'm going to do a very brief introduction. For those of you who want the Wi-Fi password, I'm going to put it up on the whiteboard here. This is about 18 characters long, and so I'm not sure you'll remember it. I'm guessing there's no problem in the back hearing us now? Good morning. We are very fortunate to have Greg Foreman here today. He's been a member of the South Carolina Bar since 1992 and practicing family law since 1993 with an emphasis on divorce, custody, and support cases. He is the past president of the South Carolina Bar Trial and Appellate Advocacy Committee. He lectures frequently on family law for the South Carolina Bar and the National Business Institute and has had numerous articles on family law published in the South Carolina Trial Lawyers Association magazine, the Bulletin, and South Carolina Lawyer. So we're very fortunate to have him here with us today, and I will turn the show over to him.
I want to thank you all for coming. This CLE was inspired by all the attorneys I've formally and informally mentored the past few years. For those of you who don't know me, I do a family law blog, and some of the blogs I do are written specifically with my mentees in mind. And one of the topics I tend to write about with them specifically in mind is the topic of discovery. And my newest mentee said, you ought to do a CLE on discovery in family court. And I realized that most of y'all, if you're like me, you open up a practice a couple years out of law school, you're doing family law, you learn discovery in civil procedure, you might have even taken a trial advocacy class where you did a little bit of discovery preparation, but you've never really had specific training in how to use discovery in a family law case. So the goal today is to try to compress what would be a semester's worth of material into 6 hours. And I'm going to try to stick to the agenda, but it may not be exactly what was written in the initial agenda. So I would suggest all of you, if you're familiar with my website, go to my blog, look for the tag, not the topic, but the tag discovery. And if you just click on that, you'll find probably about 30 to 40 blogs written specifically on the topic of discovery. And they were written with sort of an attorney who practices family law with 3 to 5 years experience in mind. So a lot of the material I'm not going to have time to cover today, that can be a useful resource for you. When I suggested doing this CLE, I envisioned sort of a much smaller room, and so I'm glad to have this huge attendance, but I just think it's going to be a little bit difficult for y'all to follow what I'm trying to show on the screen. So what I'm showing on the screen today is all going to be either in my materials, and I'll tell you the page number when I'm referencing my materials, or it's going to be on the South Carolina Courts website. Does everyone know where the South Carolina Courts website is, or does someone need me to give the address? If anyone needs me to give the address, just raise your hand. And does everyone know how to get to the rules section on that website? I'm going to be referring to rules of civil procedure or rules of evidence throughout the day. And so if you can't see that board, then you're going to, I'm going to just ask you to either be on the website or be on my materials, and I'll tell you where we are on my materials on the website. So, discovery in family court, well, in any type of case, the goal obviously is to use discovery to bolster your settlement position, because 90 to 95% of your cases, I assume, are going to settle. And if you don't settle the case, also to be prepared for trial. So lot of times, clients will ask me at the beginning of the case, why are we conducting discovery when, my goal is settlement? And I say, well, because I can't really settle the case on favorable terms for you, most likely without conducting at least some discovery. And obviously, the better information you get in discovery, the more favorable terms you can get. The metaphors I'm going to use today quite frequently are war and poker. And I don't play poker, and I've never held a loaded weapon, but they're still useful metaphors. And the reason poker is a useful metaphor is a trial is kind of like a game of poker. The judge is, what's going to happen to the judge is unknown, but you know whether you have a strong hand or a weak hand. The other side may be bluffing, but you're really not sure. But certainly you're going to have a much stronger position if you're holding 4 kings than if you're holding, a pair of 7s. So discovery is how you learn whether you're holding 4 kings or a pair of 7s. And I have thought long and hard about what I'm trying to accomplish in discovery, and even thinking through this materials when I first mentioned the CLE to Michael and Dana Atkins, I thought of 5 different things I'm trying to accomplish in discovery, but really when I sat down to write the materials, I realized that one of those things was actually 2 separate things. So the first thing I want to talk about is the 6 things you're trying to get out of discovery. And a lot of times when you're drafting discovery, you're going to, certain types of discovery are designed to get you 2 of the same thing, but you don't really know what it's going to be until you answer. And it'll make sense in a second, so let me show you what I mean. Going to, on page 1, the first thing you're going to do with discovery, one of the first thing I list is learn what information the other side intends to provide at trial. And the second is limit the other side's ability to present evidence at trial. And pretty much any discovery designed for issue 1 is also going to pick up issue 2. And anything designed to pick up issue 2 is also going to pick up issue 1. And now I'm going to Rule of Civil Procedure 33B. These are the standard interrogatories. And I would contend the standard interrogatories relevant to family court cases are all designed to pick up those 2 issues. The very first standard interrogatory is basically names and addresses of the witnesses. So the standard interrogatory 1 is designed, as I said, to get you the list of witnesses. Well, if the answer is witnesses John and Jane and Mary, well, that tells you about the other side's case, but it also limits the ability of the other side to call Bill and Dana because they aren't listed as witnesses. So interrogatory questions designed to figure out the other side's case or what they're trying to present at trial are also designed to limit the other side's ability to present evidence at trial. That is, when you're answering interrogatory, standard interrogatory number 1, list the witnesses you're going to use, but if you don't list witnesses, don't be surprised when those witnesses, when you call them at trial, can't be used. And if the other side lists witnesses and then doesn't list a witness at trial, doesn't list a witness in their interrogatory answers, you can preclude that witness from testifying or get a continuance. I had a case against one of you just last week where they listed a witness at 3 p.m. the day before trial, and they showed up with 3 attorneys and an expert witness, and their client had come down from Virginia, and the court was going to give me a continuance because I didn't have time to prepare for that witness's testimony. So they'd answered their initial interrogatories 2 months before that. So certain, well, we'll talk about supplementing interrogatories later today, but one of the things discovery is designed to do is to, as I indicate, learn what the other side intends to provide at trial and limit their ability to present evidence at trial. If we go through the standard interrogatories, we'll see that they're almost all the ones that are related to family law are all those types of questions. Number two, it's basically, what's your exhibits? Give me a list of your exhibits. Well, if it's on the list, you can use it, but if it's not on the list, you can't use it. Number three, well, number three you're not going to use, but number four you're not going to use, number five you're not going to use. Number six, who are your experts? Again, it's a list. If you list the expert, they can use it. If they don't list the expert, they can't use it. Number seven, what are the witnesses going to testify about? And you don't have to give every single response. You don't have to give a detailed list of what they're going to testify, but you've got to give general areas. If you list someone as a witness to the party's parenting ability, and then you start asking them about the other side's adultery, don't be surprised if you get an objection and a limitation, because if you list a witness as testifying about the party's parenting ability, I'm going to prepare a cross-examination of that witness on their knowledge of the party's parenting ability, but I'm not going to be thinking about adultery. So, again, all the standard interrogatories are basically designed to accomplish the first two goals that I've listed in discovery. Now, one other thing I would mention, when you see discovery, when you issue discovery, a lot of times I see discovery that is not related to any of these goals. And if y'all can tell me another goal in discovery than the six I mentioned here, I'd be happy to add to this list, but this involves 23 years of thinking about it. And when I added a second one, what I basically did is added number two, which is really just the converse of number one. I mean, there's not really a new area of information I'm trying to glean in issuing discovery. But I'll see cases where there are no children, and I'll be asked custody type fitness issues in discovery, and I'm sitting there thinking, why is the other attorney doing this? I mean, if that's how they want to use their 50 supplemental interrogatories, fantastic. But you're not thinking about your case if you just issue discovery that's not designed to accomplish one of these goals. The third goal is to learn the opposing party's position on contested factual issues. And these are typically done with supplemental interrogatories. And by the way, I'm assuming y'all are conversant in the language of discovery, but if I use a term that one of you doesn't understand, raise your hand, okay? But I'm assuming y'all are conversant in it. So those types of questions are, I think, best dealt with in supplemental interrogatories. That is, I use supplemental interrogatories. I think those are the best tool for learning the other side's position on contested issues. And one should, I have sort of go-by supplemental interrogatories for certain types of cases, and I have some I use in almost every case, and we'll talk about that a little bit later. This is sort of an introduction that's going to help everything make sense later on. But the learning the other side's position on contested factual issues requires you to think about what factual issues are contested. You're going to see a bunch of form supplemental interrogatories later in the materials on child custody. But I don't use all of those. They're just sort of ones I can pick and choose from. For example, if religion is a huge issue in this party's custody fight, I've got a sort of standard question designed to elicit the other party's position on religious issues. But if religion is not an issue, I'm not going to use that as one of my 50 supplemental interrogatories. So think about what's contested, and you're probably going to need to draft, specialized supplemental interrogatories for each case. When I see another attorney issuing me discovery where it's clearly just a form and none of the discovery questions are specifically related to the facts of that case, what I think is I'm dealing with an attorney who's really not thinking about the case. And you're going to get a much worse settlement offer in that case, because I'm just thinking you're not really thinking about your case. On the other hand, I see discovery issued where it's very clear that the attorney has thought about the issues in this case and the discovery is designed to accomplish these goals. Then I know I'm dealing with somebody who's going to be prepared for trial and isn't just simply on a pathway towards litigation, towards trial that they're not really thinking about. They're just sort of on automatic pilot. So types of questions you might ask are as simple as, what property do you think is subject to equitable distribution? What do you contend is a fair equitable distribution of this property? And why is this fair? That's a perfectly good question. Now you will probably get a somewhat vague answer, but that vague answer will certainly help you frame a number of additional discovery questions. Remember, you don't need to ask all 50 at a time. I have cases where I issue 5 or 6 sets of supplemental interrogatories because as new information comes in, I begin to realize where the real areas of controversy are, and then I can be even more tailored. But it's useful to somewhat start out with a broad approach versus a narrow approach. I often describe types of discovery as a shotgun versus a rifle. Rifle is designed to sort of clear everything in its path, or might be a better metaphor would be a net versus a hook. Net, trying to pull up everything. A hook, you're trying to look for something very specific. But initial rounds of discovery, those sort of questions that go wide, make a lot more sense. Later on, when you're issuing more discovery closer to trial, a much more narrow approach is often useful. But the third task, I think, is to learn the other party's position on contested factual issues, and I find that supplemental interrogatories are the best way to do that. The fourth area of discovery is to obtain the information in the other party's control that might be helpful to one's own case. And this is generally accomplished, I think, best through requests for production or subpoenas. But I'm going to start with requests for production to see if I can get it easily from the other side versus issuing subpoenas. But there are times where I'm definitely going to want to issue a subpoena as soon as possible. And the reason requests for production work well, because you're really just at this point looking for documentation that's going to help your case. Something I may talk about a little bit later found time, but it's in the materials. Social Security earnings statements. I almost always want the other side's Social Security earnings statements because it's just a trove of useful information. You want to understand the economic circumstances of that party, assuming they generally made their income through labor. That's going to be a very useful way to do it. And if there's some sort of disconnect between lifestyle and claimed income, that's going to be your starting point to document that. I had a case I just tried about 1.5 years ago where this party never showed wage income greater than $39,000 a year, but he had a lot of unexplained deposits in his bank accounts. And my client contended they were due to sort of side jobs, and he acknowledged that he'd done side jobs in the past. But when we subpoenaed his bank records for a decade's worth of bank records, in 6 years this guy managed to save $72,000 on $39,000 income. That's pre-tax income. And this is also while he was paying a lot of household expenses and mortgage, and that does not happen. And so, but having that Social Security earnings statement, I was able to demonstrate that no guy making no more than 39,000 a year is going to save $72,000 in 6 years. And the court accepted our argument that these unexplained deposits were evidence of side income. And you want to think about one thing. The one area where I will certainly issue sort of standardized requests I have is request for production. I don't cast a very wide net. If you ask me if I see a request for production for like every bank statement from the date of the marriage to the present, I'm thinking somebody's getting overly broad in their discovery request unless it's a short marriage. Is there any way we can cut the feedback on this? Okay. But I will often I have sort of a standardized request for productions, and I'm not going to issue all of them. Some of them are relevant only to custody or support cases. Some of them are only relevant to alimony cases. But some of them are only relevant to equitable distribution cases. But certainly you want to cast a relatively wide net to find what might be useful in your case. Typically, if I go to trial, I'm going to be using a bunch of documents that I obtained from the other side in request for production, and that requires thinking initially about what sort of documents the other side might have that would be useful in your own case. The fifth thing is to attempt to obtain useful admissions from the opposing party that can be deployed at trial. And the sixth thing is to obtain information from the opposing party that can be deployed to impeach that party's credibility or the credibility of that party's witnesses. And I talk about those two together because they are truly linked. That is, a lot of the discovery you're going to issue, you aren't going to know up front whether the response is going to get you a useful admission or impeachment evidence, but the response will get you one or the other. Let me give you a typical example. Let's say you've got pretty solid evidence that somebody's committed adultery with so-and-so, but you don't have absolute rock-solid proof. So you ask them to admit or deny that you've committed adultery with so-and-so. Well, if they admit it, then you've got an answer that works on goal number 5, obtain a useful admission from the opposing party that can be employed at trial. And you just submit that answer to the request to admit at trial and say, they've admitted adultery with so-and-so. On the other hand, let's say they deny it. Well, now, I'm not only going to try to prove that fact at trial, but I'm going to use the fact that they denied it. I'm going to go both prove the adultery, and I'm going to show not only is there adultery, but this person is lying about the adultery, and that should affect their credibility overall. So the fifth and sixth goal work together. You're going to issue a lot of discovery. Typically the discovery that's going to work on the fifth and sixth goal are depositions. Well, depositions will probably help you accomplish every goal but number 4. But they're going to definitely request for admissions and some interrogatories, supplemental interrogatories. You're not going to know whether it works towards goals 5 or 6 until you get the response, but it's designed to work towards one of those goals. And requests for admissions especially, I mean, they're only basically dealing with issues 5 and 6. If you're issuing a request for admission that is going to help you with goal 5 and 6, you need to ask yourself why you're issuing that request for admission. I'll give you a perfect example of a request for admission I see a lot, but don't think is terribly useful. Admit or deny you are an unfit parent, or some variation thereof. Okay? Now, if my client denies it, which they almost certainly will, you know you're not going to get a useful admission from the opposing party in that response. But when you get that denial, I mean, how are you going to use that to attack their credibility at trial? Every parent that you're going to see in family court will probably have a reason to explain why they're fit. I only use cocaine when the child isn't present. the corporal discipline I exercise on the child doesn't leave bruising. I mean, you're going to get an explanation. It's not going to impact credibility that well. Can you hear me now in the back, or no? I'm just... I'm trying. Okay, excellent. So a request to admit that doesn't accomplish one of those goals is not a useful request to admit. And that's why I often get attorneys to ask me for go-bys on a request to admit, and I'm sitting there thinking, why would you ever have a go-by for a request to admit? A request to admit is going to be completely tailored, not just to the specific facts of your case, but to the specific controverted facts of your case. If there's something that's already acknowledged, not in dispute, there's no need to use a request to admit to knock it down. If I have my complaint says you've committed adultery with so-and-so on such and such date, and you admit that in your answer, I don't need to use one of my 20 precious requests to admit to establish that fact. So, does everyone understand? Any questions about the concept of, can you hear me in the back now? Is this still working? Okay. You can hear me in the back? Okay. Any questions about this before I go on to the next topic? Okay. The next thing I want to talk about is discovery before substantive temporary relief. I am told by some family court judges I know that I'm the only attorney they know who does this, and it's just such a useful tool. I assume most of you that practice family law, when you file your complaint, you almost reflexively file a motion for temporary relief with your complaint. Is that pretty much your standard? And there's sometimes that makes sense, but there are a lot of times it doesn't. I mean, there are cases I feel I've lost my motion for temporary relief as a plaintiff because I just didn't conduct discovery before I filed my motion for temporary relief. And there's nothing in the rules of civil procedure. I mean, the rules of family court basically allow you one opportunity for temporary relief unless you can show a pendente lite change of circumstances during litigation. But nothing says that motion for temporary relief needs to be set when the complaint gets filed. So let's say I've got an alimony case, a divorce and alimony case, where my client can go a few months without alimony, and I really don't know what the other side's income is. You know, I may not want to rush into a motion for temporary relief to set alimony when I don't know what the other side's going to claim their income is at that temporary hearing. So it might make much more sense for me to go get an order of discovery, conduct some quick discovery, and then file my motion for temporary relief. Where I think it works even better is custody modifications or relocation cases. I mean, I think a family court judge is very reluctant to allow relocation without, on a 5-day notice temporary hearing where there's been no discovery, there's no guardian. And so I think you have a very high burden, especially if the relocation is somewhere where the other parent's not going to be able to exercise regular visitation. And I found it much more effective to have my clients plan, and I tell these folks who think they're going to relocate, let me know months in advance, and I will file my action for relocation, but instead of filing a motion for temporary relief, I'll file a motion for guardian and discovery. And then, a lot of times when I'm trying to do relocation cases, most people, if they have school-aged kids, want to relocate typically at the end, sometime during the summer. And it's perfectly fine to relocate at the end of summer because summer often gets divided between the two parties. So if you file your relocation case at the beginning of summer rather than the end of summer, if the court gives the other parent half the summer, it's really not a huge deal. And by the end of that 3 months, the guardian's probably had a chance to investigate. And if the guardian sits there and says, yeah, this non-custodial parent really doesn't have sufficient relationship with the child to act as custodial parent, and yes, this move is pretty compelled, you're very likely to win a pendente lite motion to change custody. It just will, or to allow the relocation. It'll just happen at the middle, it'll happen a few months into the case. Whereas if you just file your motion for temporary relief at the beginning of the case, it's been, the other side's only had 5 or 10 days notice, 5 to 10 days business notice of the motion. Courts can be very reluctant to allow that sort of upending of the status quo on a temporary hearing. So, file your motion for discovery and the guardian at the beginning of the case, then go for the change of custody. I had that work very well in a custody case quite recently. The allegation was that stepdad was smoking marijuana with the son, but the only evidence we had of it was the son's sort of Facebook conversations with his girlfriend. But we filed a motion, filed an action to change custody, asked for temporary drug testing, guardian discovery. Guardian goes in and investigates, finds that the son can even show where the stepdad keeps his marijuana. The stepdad tests positive for marijuana. There was also some physical abuse allegations that the guardian was able to substantiate. There was some academic issues that the guardian was able to substantiate. And when we filed a motion for temporary leave to change custody, I was pretty confident, much more confident I'd been had I filed that motion for temporary leave at the beginning of the case. Custody got changed, pendente lite, and they settled on a permanent change of custody. Well, if you go into that same case, you file for the change of custody at the beginning of the case, you lose, the court appoints a guardian, the court allows discovery. Now what happens? Now you're basically waiting for trial for the other side to have any incentive to consider a change of custody. And so that a year goes by, the other party has time to clean up their act. For my client, it's going to become incredibly expensive to gear up for trial. And so you're certainly not going to get an agreement to change custody until mediation 6 to 8 months down the line. And so you've just hamstrung your own case. So one thing I would encourage you to do when you file your complaint is to think, do I need temporary relief immediately, or can I, and also am I much more likely to get the temporary relief I'm seeking if I have conducted some discovery? Because nothing in the rules prohibits y'all from seeking an order of discovery, and nothing in the rules prevents you from filing your motion for temporary relief in the middle of the case rather than the beginning of the case. Stipulating the discovery. As you know, in family court, you either need an order of discovery, but Rule 25, let me pull that rule up. Family Court Rule 25 specifically allows discovery by stipulation of the parties. So you can file a written stipulation signed by the parties or the counsel if they've got counsel, and you can start conducting discovery before the temporary hearing with that stipulation. You can start conducting discovery without a temporary hearing. Not only that, filing it as a stipulation rather than consent order, you save the $25. Most county clerks are not charging you the $25 to file a stipulation. The rules aren't really clear whether they should be or shouldn't be, but you can save your clients a teeny bit of money, have it go a lot faster. And so one thing you can often do if need discovery, you've got an attorney you're working with on the other side, but you don't need a motion for temporary relief, just file a stipulation for discovery. Now, in conducting discovery, there are limitations on discovery contained right in Rule 26. And I'm looking now at page 5 of the materials. Discovery, you can basically conduct discovery on anything that might lead to the discovery of admissible information. But and so that's a pretty broad scope for discovery. But there are limitations on it contained in Rule 26A. And those limitations are the discovery sought is unreasonably cumulative duplicate, or is obtainable from some other source that is more convenient, less burdensome, or less expensive. Is the primary one that I think I use to try to limit discovery. Now I would note that letter C, or letter number 3, describes unreasonably burdensome or expensive, taking into account the needs of the case, the amount of controversy, limitations on the parties' resources, and the importance of the issues at stake in litigation. There's been a recent change to the federal rule of civil procedure, with discovery, that makes this sort of limitation much more important. Chief Justice Roberts is sort of pushing discovery reform, and this is the way he's pushing it. But I suspect that perhaps in the next few years we're going to have a similar modification to our rules, because we tend to track what the federal system is doing. And you see a case where there's a 5-year marriage and the parties don't have a $100,000 net worth, and one side is seeking 6 years of bank records and 6 years of credit card records and all the deposit slips, and at that point I'm likely to just object under Rule 26A grounds. A lot of times I see discovery where they're asking my client to produce records from joint checking accounts, and if my client's the only person who has a password on that account, I'll probably tell my client to go download those records and obtain them. But if both parties have access to that account, the discovery sought is obtainable from some other source that's more convenient. Well, if you want those records and they're in your client's control, you go get those records. And I'm perfectly content telling the other side, these are in your client's control just as much as mine. You do the work if you want it. Now, a lot of times I'm going to have to get those records. I'm not going to object because I'm going to want those records anyway. And but if it's something where I really don't need it, or it's going to be a pain for my client to obtain, let's say they request tax returns, joint tax returns. Well, if neither party has them, someone's going to have to order from the IRS. If I don't want them, I'm going to tell you, you can obtain them from the IRS just as easy as my client can. You want them, you go obtain them. That's a perfectly legitimate objection. And in issuing discovery, I would counsel you, if it's stuff that's just as equally available to your client as the other side, don't issue requests to produce those documents. And there's good reason for that. When I have my client obtain these documents, I'm going to look through, assuming the other side hasn't requested them, I'm going to look through those documents, and what's useful to my client will be produced as documents, assuming you issue a discovery request for documents I intend to use at trial. I'm going to produce those documents because I'm going to use them at trial. But I'm not going to produce the documents that might not help my case, might even hurt my case, that I don't intend to use at trial. So if it's a document request, a lot of times at the beginning of the case you're going to have your own client do a bunch of fact gathering. If my client, it's an equal distribution issue, Or, I'm gonna have my client just download every bank statement that they have access to online, every cell phone record that they have online. Most couples nowadays have joint cell phone accounts. And you can get detailed records of every incoming and outgoing call and text message on every line. And I'm gonna have my client download that as quickly as possible, because a lot of times they've never looked at these detailed bills and they're surprised to see their spouse having endless phone calls and text messages with some unknown number. And I'm going to want to know who that number is. So, but if you simply wait on the other side to obtain those records that are easily obtainable by your client, you're waiting quite a while. You may get a halfway response. You may end up producing records the other side would never see, or they may be obtaining records that they would not normally see otherwise, that may be very harmful to your case. So be cognizant of asking for too much, or for asking for things that are within your own client's possession. We all know that there are limitations on supplemental interrogatories and requests for admissions. Now, there's two types of requests for admissions. There's requests to admit the authenticity of documents, and those are unlimited. There's also a request, the basic request to admit that we typically issue, you're limited to 20. On supplemental interrogatories, you're limited to 50, including subparts, and I see some attorneys taking advantage of that by asking one question with like 10 subparts. And if the subparts are truly related to the initial question, I think it's legitimate, but the subparts are really just 10 questions, and the guys of one question I may object. I don't really see that all that often. But because there are these limitations, I would never issue 20 requests to produce with my initial discovery request. I would never issue 50 supplemental interrogatories in my initial discovery request. Start with 5 or 10, because your first batch of responses are going to lead to new questions, almost certainly. Discovery questions, supplemental interrogatories, as I said, oftentimes they are they've got to be created whole cloth in each case. You have a question, Amanda?
Yeah, I have one before you use the limitations.
Yeah.
Numbers. I've got a situation. I wanted to see what your experience was with a lawyer that did issue well over the 50 interrogatories, including subparts, and it was like 93. So I advised my client to answer the first 50, and then I objected to the rest.
The question was, how do you respond when you get a supplemental interrogatory request with more than 50? And I assume also what would you do with a request to admit that was more than 20? And what she does is she just has them answer the first 50 and ignore the rest. And I think that's a legitimate way of dealing with it. My typical way of dealing with it is to let the opposing attorney know you've issued more than I'm required to answer. You've issued, and I'm not going to answer all of them, but if you let me know which ones you want answered up to the limitation, I'll answer them. And usually I get a response. But if I got no response, I guess at that point I'd either answer the first 50 or file a motion of protective order if I didn't want, but I think just answering the first 50 is a good way to handle that. But as a matter of collegiality, I would probably ask them which 50 I want to answer before I just answer the first 50, but I don't see anything wrong with the way you approached it, Amanda. I don't think any family court judge is going to compel you to answer more because the other side didn't read the rules. Now, I would also suggest that for a lot of supplemental interrogatories, if you want to ask more than 50, ask yourself which of these are better designed for depositions. I mean, if you're going to try a custody case or an alimony case or an equitable distribution case, I assume enough is at stake that conducting a 4-hour deposition of the opposing party might be the most useful 4 hours in the whole trial prep. And, questions as to why one should get custody. You can certainly ask an interrogatory, list all the reasons you should get custody and explain what evidence you have to support these reasons. And you might get some useful information, but you're probably going to want an explanation after you get that answer. And so a deposition might be a better way to handle that sort of issue. And if you run up on, oh my God, I'm getting close to 50, then that might be a question you just don't ask. So supplemental interrogatories that are useful in almost any family law case is at page starts at page 7 of the materials, and these are ones I developed relatively recently, but I just find them always getting you useful information. I'm assuming at this point you've had a temporary hearing. If you haven't had a temporary hearing, or if the other side hasn't issued a financial declaration, or your client hasn't issued your client hasn't issued a financial declaration, I wouldn't issue these supplemental interrogatories. If you have, then they're useful. One is just in the affidavits we provided at the temporary hearing, what you contend is inaccurate and why is it inaccurate. And the reason that's a useful interrogatory, I assume you all figure out, is, at trial, they're going to try to pick holes in what you submitted at the temporary hearing. One thing I'll talk about later is we get to Rule 801 of the Rules of Evidence. The statement of a party opponent, which makes it non-hearsay and admissible, is not just the statements that come out of that party's mouth, but any statement that that party manifests a belief in its accuracy. And I would contend, and I've always successfully contended, that any affidavit the other side provides at the temporary hearing, they are vouching for its accuracy. Yet to have I think the first opposing party that gets up on the stand says, yes, I submitted these affidavits, but I didn't intend the court to rely on their accuracy. It's going to have some real credibility issues when it comes to the final order. So, it's useful, I can attack the other party's credibility not only on that party's affidavit, but on all the affidavits they submitted at the temporary hearing. If it ends up that a bunch of them were full of baloney, I can say, you told the court, you had your witness tell the court this, and this wasn't true, was it? You had the court, this witness tell the court this, and this wasn't true, was it? And that impacts not just that witness's credibility, it impacts the party's credibility. So they can make the same attack on you. So I want to know, what do you contend is inaccurate in the affidavits I submitted at the temporary hearing? And if the answer is none, then I don't need to establish the accuracy of any of those facts at trial. If they start attacking the credibility of these affidavits, I'm going to say, Your Honor, they told me they were accurate. They shouldn't be allowed to attack the credibility now. They told me but if they tell me this is inaccurate, and this is inaccurate, and this is inaccurate, then I know I need to establish those three facts. Actually, those three facts, if I can, at trial. I ask a similar thing on financial declarations. Is there anything in my client's financial declaration that you contend is inaccurate? And if the answer is, I think the utility expenses are inaccurate, well, I'm going to go have my client pull 10, 12 months of utility bills for every utility. And I'm going to add it all up, and I'm going to average by 12, and if it's pretty close to what we listed, then I'm going to use that as an exhibit at trial. And I'm going to produce it in discovery, and I'm going to say, they contend that this was inaccurate, but here's the proof. If, on the other hand, they don't list the utilities as being an inaccuracy, I'm not going to go gather a lot of evidence to prove the accuracy of the utility list expense. Now, the answer you might well get for that is to be supplemented as one conducts discovery. And that is a perfectly legitimate answer early on in the case, because you really, without a lot of discovery, won't know what's inaccurate in the other side's financial declaration. The thing is, Rule 26 is very specific, ongoing duty to supplement responses to interrogatories, requests to produce, and requests to admit. And so if you say to be supplemented and you never supplement, then the answer is basically there's no inaccuracies by the time you get to trial. So one thing I'm going to mention quite frequently today is the ongoing duty to supplement and how that impacts trial preparation. But those two interrogatories I have found to be extremely useful in preparing for trial. In every case where there has been a temporary hearing, I'm going to ask the first one. Every case where my clients filed a financial declaration. And remember, financial issues are at stake. Even if there's not a temporary hearing, you're supposed to file and serve financial declarations within 45 days of the service of the complaint. And so I always demand financial declarations if financial issues are at stake within that 45-day time frame. There's been a few cases where I haven't had a motion for temporary relief, but I've still filed a motion to compel financial declaration. The court's granted, the court's award attorney's fees when you gotta file it. And I then want to know what the other side contends is inaccurate in my client's financial declarations. So supplemental interrogatories are useful in most divorce cases. I've found that there are 3, and they're at pages 8 and 9 of my materials. And the first is basically state the date of the separation, the reasons for the marital separation. You just want to learn why the other side thinks the marriage broke up. Because sometimes you got fault grounds, but that's not really the reason the marriage broke up. And sometimes there aren't fault grounds, and you need to learn why the other side thinks the marriage broke up. If it's just going to be an issue at trial, you might as well know it before trial. The other 2 are related to adultery. One is basically what adultery has the other side committed, and what adultery does the other side contend you've committed. And I will not belabor the obvious as to why you asked these questions, but I'll just note that I see cases where folks don't conduct discovery, they agree to alimony, they get a final order, and then they learn about the adultery after trial, and they haven't conducted discovery. Or not after trial, after they get the agreement approved. They haven't conducted discovery, and too bad, so sad. I mean, the rules are very clear. We don't even allow 60B motions for extrinsic fraud. You had a question, Audrey?
Yeah, just on the supplementary interrogatory about adultery. I'm pretty sure I know the answer, but I just would like kind of second opinion on it. Because I know that your discovery isn't supposed to be a fishing expedition. But would it be kosher to ask about adultery even, maybe you kind of suspect it but don't have any, firm...
Even when I don't suspect it, I ask. Okay?
That's what
I've got 50 in a divorce. This is now a divorce case, I presume,
Yeah.
because I wouldn't be asking this otherwise. And I ask because the answer might surprise you. Or, even better, sometimes the answer is you don't think there's adultery, you get a denial. And remember, these are going to be under oath. Rule 33A, Rules of Rules of Civil Procedure, discovery answers need to be verified. Everyone know what a verification is? Need to be verified. I demand the verification, and we'll talk about using the verification. We talk about using discovery responses at trial. But let's say they deny under oath, and then later you learn that there's been an affair going on. Having locked them into a denial of adultery, if it's accurate, that's great. But if it's inaccurate, the fact that you ask that question and later find out they lied, even better. So I'm just going to reflexively ask.
Come up again in the day.
You have a question, Jack?
I just wanted to note, and this is a case that Greg and I had together, when you have a nightmare pro se litigant, sticking to this stuff and working it hard produces incredible advantages. A lot of them will simply stonewall all of it And it's one of the ways you can get these pro se nightmares under control.
Okay, going on to supplemental interrogatories for custody cases. This is a listing that begins at page 9. And here, I don't ask most of these in most cases. I pick and choose which ones to ask depending upon the relevant issues. Because a lot of times these are not going to be relevant. These are going to be, irrelevant issues. But I listed all of them. It's as a PDF file. It's a text PDF file, so you're welcome to cut and paste. But you also, the only one of this I reflexively ask is there anything that renders my client to have unfit to have sole custody of the children? And I reflexively ask it because the answer 98% of the time should be no. I mean, fitness is a pretty low standard, and just because your client is fit does not mean they're going to get custody. And so 98% of the time the answer should be no. But my experience is that well over 50% of the time the answer is not no. And you learn a lot of useful information about the other party in how that not no is, okay? What you might see is an overly rigid parent. You might see a parent who isn't able to see anything good about the other parent, both of which are useful facts in custody disputes. Sometimes it's great, they will list things that render your client unfit that they engage in too. So-and-so drinks too much. Well, if both of them are failing their DCDT tests, that's an answer that just gives so much. So even though it shouldn't get you useful information, I find that interrogatory in a custody case just gets really useful information. When I see an attorney who answers that question with something other than a no, unless my client truly is unfit. If my client's truly unfit, I'm probably not fighting a custody case, and I'm probably not asking that question. If my client's, a recently convicted sex offender with a crazed heroin addiction, I really don't need to ask that question, because even if I learn new ways my client may be unfit, it isn't going to help me in trial. My client's unfit. But you ask that question, these attorneys who are having their clients answer it in a way that just makes the client look bad. I don't know why they have their client do that. Maybe they don't want to exercise a lot of control over the client. But I get something other than a no a good half the time, and I would tell you that way under half my clients are unfit to have custody in the custody cases I handle. So, request for production. I've given you sort of my standard request for production, and they begin at page 12, and those requests for production, I don't necessarily ask all of them every time. Some of them are only going to be relevant to evidence fusion cases. Some of them are only going to be relevant to child custody cases or child support cases. But that's sort of, whereas my supplemental interrogatories are likely going to be, 20% sort of things I take from my forms, and, mostly things I generate based on the unique facts of the case. And my requests for admissions are going to be solely things I generate for that case. My requests for production are mostly going to be 80 to 90% things that are coming off this form, and maybe 20% will be related to the unique circumstances of that case. For example, if there was some sort of domestic incident involving the police on July 15th, 2015, I may have a specific request produced, all medical records from this incident, all incident reports, all photographs of injuries from this incident. I would create a request for production based on that specific fact, going to, but normally it's just casting a net. And the nice thing about request for production, there's no limitations on the amount. There's just simply karma and the Rule 26A limitations. If you're, one thing that there's a case, or the name on top of my head, but basically you're not entitled to an accounting of every dollar spent in the marriage as part of equitable distribution, which is a pretty smart case. Now, if you've got a good reason for asking for 10 years of bank statements other than your word processor, it's just as easy to write 10 as 3, then ask for 10 years. But typically, I think if you look just past 2 or 3 years, in most cases, you're going to get what you need. Now, in one case, I asked for 10 years, ended up having to subpoena it, but our view was that a lot of money was being transferred out of the country to parents in Europe, and sure enough, there was a lot of money being transferred to parents in Europe without any good explanation. So we contended that was funds that were basically subject to equitable distribution. But we had a good reason then for asking for all these bank statements going all the way back. Any questions so far?
I have a question about requests to produce, dealing with counseling records, mental health records, specifically in custody cases. I don't seem to see a consistency in cooperation from the counselors. They say, oh, there needs to be an order of discovery, so I
Well, they're right on that. Well, there needs to be an order, frankly, or there needs to be a
Right.
release.
But, well, help me understand, an order granting discovery is not enough. It has to be
It's not, yes.
specific.
We'll
Can
get
you
to
talk
that.
about
That's one of the
that
topics
later?
I'm talking about, yeah.
Okay.
And I actually had a case at the trial level where for the first time in my career, I think there's times where it's clearly relevant and the court should order counseling records. But in this case, I had an affidavit from the counselor saying that she is counseling strictly, well, we'll talk about it
Okay,
later.
that's
But
fine.
I don't, remind me.
Okay.
Okay, requests for inspections. I rarely do them, but Rule 34 specifically allows for requests for inspections, and the tip is to inspect land. A lot of times I'm just going to want to go inspect my client gets kicked out of the marital home very quickly before I can even get involved. I want to document what's in there. I want to have an appraiser go out and look at it. I want to video the home. And so you do a request for inspection, and what you basically do, I mean, if I've got a cooperative opposing counsel, I'll ask for a time to do it and put the time in, but if not, I'll just list a date by, and then they've got to make it available at a mutually agreeable time. The standard language for the request for inspection is at page 18 of the materials. And I note that you put in there inspect and document by photographic and videographic means, because I had a case once where the other side, we did a request to inspect, I didn't put that language in, they objected to the photographs being taken or video being taken. And the rule specifically allows you to photograph and video the inspection, but if you don't put it in there, then you get an objection raised, and I actually had to go back to court twice. Yep.
I've used it just as another use for it when there was a substantial amount of personal property, like in a safe taller than me. So that was another use for it.
And I use that often to document personal property. That's why I'm videoing it. The issues of like videoing safe deposit, doing a request to inspect safe deposit boxes and things like that. I have thought about that issue for 20 years, well 10 years, as to how you can do that. I had a colleague of mine in this office, in this meeting, this CLE today, who actually once got an ex parte order to to do an inspection because his concern was that the opposing party would sort of hide what was ever the contents of the safe between the time the request went out and the time of the inspection. And I'm not sure an ex parte order is appropriate, because it doesn't give the other party a right to be heard. On the other hand, I understand why one might want to do an ex parte order. I would think that I've never had to do it. I think if I ever felt I needed to do it, I might ask for an ex parte order, having some receiver sort of take possession of the property pending an expedited hearing on the right to inspect that property. That way, the other party at least has a chance to be heard before it's inspected. But I've seen those ex parte orders issued. Don't think they're appropriate, but I understand why people want them, because things like hard drives or safe deposit box will get cleaned out between the time the request is made and the time of the time that it's inspected. But that's the language you would use for a request for inspection. Okay. At page 19 is a certificate of authenticity. You have a question? It's a certificate of authenticity. When you issue subpoenas for records, you're going to want to be able to authenticate those records, so you don't have to call somebody as a witness at trial to authenticate the records. You'd obviously stick a caption on that, and certificate of authenticity would be in the upper right-hand corner. But this is the form I use, and what you plug in there is where it says dated, obviously it's whatever date you issued the subpoena, and ordinary course of business at, and it's the name of the entity that you issued the subpoena to. And this form has always sufficed to authenticate those records. So when you issue subpoenas, you're going to want a certificate of authenticity with it. Okay, drafting request for admissions. As I indicated earlier, there are two sort of goals in request for admissions. One is either to get a useful concession, or one is to get impeachment material. You can't know which goal you're going to meet until you get the response. But if you're drafting a request for admission and it doesn't help you achieve one of those two goals, then you probably ought to ask, why am I issuing this request for admission? Request to admit that admit you're a horrible spouse. Admit you're a lousy parent. I mean, yes, if you could establish that fact at trial, that would be a useful fact to establish. But you're not going to establish that fact through a request to admit, and you're not going to develop impeachment material through a request to admit. So I've given you at page 21, again at 21, request to admit I issued in a case somewhat recently. It was actually the case that I mentioned where I filed the motion for discovery. The child was smoking pot with a step-parent. These are the ones I issued. They never had to get answers. The case settled before then. But let's sort of go through them. And the first one, admit or deny that after being served with a complaint in this action, you discussed at least some of the allegations of the complaint with your children. Well, if they admit it, everyone can see how that would be a useful admission, right? I mean, this parent is clearly acting inappropriate, clearly putting pressure on the child, clearly, not acting appropriately. But if they deny it, I can put both the guardian and the forensic examiner up on the stand and say, children mentioned this happened? Yep. And now becomes a credibility contest between a parent versus the guardian and the forensic examiner, and that's not a credibility battle that most parties are going to win. So good track. Number 2, admit or deny that your son's school performance significantly declined during the 2014-15 school year and the first semester of 2015-16 school year. Well, if they admit that, that's a useful fact. I mean, the son's school performance was significantly declining during the year and a half prior to my client filing to change custody. Now, if they deny it, they could deny it on a number of different reasons. They have a bunch of things. Well, you don't really state what significant decline was. Well, this was a 1.5 GPA decline. So if they don't see a 1.5 GPA decline as significant, I think that's a useful bit of information for the court to know, because most parents, I think, when your kid suddenly has a 1.5 GPA decline, are going to go into some sort of mode of addressing it, and this parent had not really addressed it. So if they deny it, I'll ask them about it at trial. You deny this, why do you deny it? And I really don't care what the answer is, because none of the answers are going to be helpful to their case. The answer would probably be something like, well, it wasn't a significant decline. And I can live with that answer, because then I would go, well, say 1.5 GPA decline didn't, going from honor student to D student didn't concern me. The answer is, no, it didn't concern me. Great. The answer is it did concern me. The next question is, and yet you didn't address it. So, number 4 I'm going to jump to. Admit or deny that since November 14, 2014, which was the date of the last final order, that prior to this action being filed, you were aware your son was using marijuana. Now, again, I don't really care how they answer this question. The son was using marijuana. If they were aware of it, then the follow-up question is, well, why? What did you do about it? The answer is nothing. If they weren't aware of it, questions then become, well, you were smoking it with your husband. Why weren't you aware of it? And so, either way, I'm either going to get a useful admission or impeachment evidence. But I think this, you can see from this, how each request to admit is unique to the factual circumstances of the case. What you're doing with request to admit is just sort of laying a trap for the opposing party. Admit something that's a helpful admission to my case, or deny it and be subject to having your credibility attacked. And that's really the only good request to admit, is one that sort of lays that trap. Any questions? Depositions. Okay. One of the, you need to think in your case who you need to depose. And there are basically 3 categories of witnesses I'm going to depose in a case. One category is witnesses who are going to be unavailable for trial. Just yesterday I took 4 telephonic depositions. And 2 of them, all of these folks lived in Florida. And 2 of them were friendly witnesses. So these friendly witnesses, they're not going to come up to South Carolina for trial, but I want to have very relevant things to say on the issue. These are relatively short depositions. They took under an hour each, but it's the only way to preserve their testimony for trial. And so, if you know of witnesses that you want to present their evidence to court, but they're going to not be available when the case gets called to trial because they live out of state, or you already know they're going to be out of the country or out of town that time. When you get your trial dates, ask your witnesses, do they have a problem with those trial dates? A lot of times I'm taking, with the opposing attorney's permission, their depositions for use at trial. Let's say somebody plans on be on vacation or already booked the cruise tickets we could try. I mean, you could be an utter butt and, you know, subpoena them anyway and make them cancel their cruise. But I think most attorneys, opposing attorneys, will certainly let you take the deposition of that witness to preserve their testimony for trial. But if you don't let the witnesses know when the trial date is, when you've got a trial date, you don't have the opportunity to have them say, I'd rather be deposed, and you may end up with the choice of either force them to cancel vacation plans, which is going to turn a friendly witness quite hostile, or make them, or forego their testimony. So witnesses are going to be unavailable for trial. You got a witness who's like dying, frankly. Yeah, take their deposition. Because, you know, if they've got something useful to say, they're willing to help you out, but they might well die before you get to trial, you can still use their deposition at trial if they're dead. So think about what witnesses might be unavailable. Because witnesses that are unavailable, you can automatically use their deposition at trial. The rules you'll need to look at first is Rule 32A3B, the Rule of South Carolina Civil Procedure, which always authorizes the use of a deposition at trial from that specific case if the party lives out of state or lives more than 100 miles away, unless it appears that the absence of the witness was procured by the party offered the deposition. That is, if you have a local witness, you take their deposition, then you tell them, you know, they're going to ask you a bunch of really damaging things at trial, so you better scoot off to Georgia. You know, if the court finds out about it, the opposing party finds out, you're not going to be able to use that deposition at trial. And this creates sort of a tactical problem when you are the other party, one party notices the deposition of a hostile witness that may not be available for trial, but you know, it becomes a question of, do you present all your helpful testimony in your cross-examination of that witness? Because if that witness, you know, then doesn't appear for trial, you're sort of stuck with what that is in that deposition. So I don't necessarily want to lay out my cards when I'm the one defending the deposition, but if that witness then becomes unavailable, the other side has the right to use portions of that deposition at trial, and you're sort of stuck with what you asked that witness, and there's no really right answer to that. It's just a consideration to keep in mind. The other two types of witnesses I often depose before trial. I like to depose certainly really hostile witnesses. Let's say it's a custody case and the grandparents are the ones kind of driving the party. We see that, I think, a lot more. Well, if I really know the main sort of push on the custody cases, the other side's parents, I may want to depose the parents just to find out what they're going to be coming at me with at trial. Alleged paramours, I'm going to want to depose, you know, pretty early on in the case. See if you can lock them into, you know, admitting the relationship. But you also want to, if they're going to lie about it, you want to learn about it, you know, early on. And we'll talk a little bit later about, in answering discovery, I talk about presenting PI reports. I actually, you know, want to depose at a minimum the paramour and preferably the other party before I produce my PI report. And but typically, I also want to depose the opposing party right before trial for reasons I'll explain in a moment. So the timing of when you release the PI report becomes useful or important. And one reason I depose the paramour early is the court will generally allow you to hold on to the PI report a little bit longer, long enough to at least depose some folks, but it won't let you hold on to it until right before trial. So so at least get the testimony of one of the two parties to the adultery before they see what your PI observed. So I'm going to depose the paramour quite early. And then
Do you think that's necessary if in fact you've already recovered the information from the questions?
well, I mean, I'm only going to depose the paramour in a case where they deny the adultery. Okay, I got a PI report. I see them holding hands. I see them snogging. I see them going into a hotel room at 11 p.m. I see them coming out of the hotel room at 6 p.m. But we're just good friends. Well, yeah, they don't necessarily know what dates I have and what information I have if they haven't seen the PI report. So, you know, it's a lot harder for them to sort of concoct, fictitious stories if they don't know what I know. So that's why I'm going to want to depose the paramour early. Now, if they admit the adultery, yeah, I'm not deposing the paramour, okay? But it's only when they deny the adultery that I'm going to depose the paramour. But I'm going to want to depose the paramour before I release my PI report. And I know that I probably can't wait till trial to release my PI report. Finally, I'm going to depose the opposing party typically about a month before trial. Certainly not until I get my trial date. And the reason for that, I mean, ideally I'd love to depose the opposing party twice. Once pretty early on in the case, and once at the end of the case, so I can cover things that I've learned in discovery or cover things that happened during the litigation period. But the rules of civil procedure authorize a deposition only once unless the parties stipulate for more than one deposition or unless the court grants a second deposition. And in theory, I guess one could ask the court to grant a second deposition. But I think given the rule, you'd be very unlikely to get it unless there's some extenuating circumstance. I've had cases where a party requests additional relief in a new pleading after I've deposed that party, and I've generally told the court that I'm prejudiced unless I can depose them again, and they'll generally only grant the amended complaint or supplemental complaint if I'm granted leave to depose that party again. But typically I won't get the right just to depose the opposing party twice. So, yeah, the reason you're going to wait till near the end to depose the opposing party is that, you don't know what the discovery is going to show, the trial, things that happen in the litigation period. You're going to want to have a right and the ability to ask the witness the party about those types of things. And so I usually wait till the end. I know that when Judge Creech was administrative judge in Berkeley County, he would often ask you, have you completed discovery and request your trial dates? And my answer would always be everything but deposing the opposing party. And he'd get sort of frustrated with that answer because I hadn't completed discovery. But I'm just not going to notice the opposing party's deposition until I know when my trial date is. And that's one of the many reasons I don't like standby dates is, you take the deposition prior to a standby, and then it's 3 months to go by, and you have no ability to really conduct deposition on what happened during those 3 months. I have listed at page 23, just to give you an idea of how to draft supplemental interrogatories. An issue that kept coming up in 2014 is I would have a custody case or visitation case, or I represented a father who had been exercising pretty substantial time with the child, and all of a sudden mom, but not married to the mom, and all of a sudden mom was withholding visitation after they broke up. And so we get to the temporary hearing in an attempt to limit my client's contact with the child. Mom would allege a history of domestic violence that the domestic violence occurred after the breakup or right at the time of the breakup. I wouldn't necessarily see it as some sort of fictitious move to deny my client visitation, but if it was happening for 2 or 3 years during the relationship, but I still let him watch the child, while I went to work 4 nights a week. I find it a little bit off. So I thought, I'm going to try to develop sort of standardized requests for standardized discovery to deal with domestic abuse allegations and domestic violence allegations. The material at page 23 shows you what you can use. So the first one is an interrogatory. That's sort of designed to get all the information I can get about what their allegations of domestic abuse are. Describe each incident, give you the information about the incident, tell me whether the police were called, tell me whether you were injured, tell me whether you got medical treatment. And letter F is pretty useful. You'll never get an admission to that. Like I was drunk off my behind when this happened, or I was high on oxycodone. But my own experience is a lot of domestic violence between couples occurs when one or both of the folks are not in the best state of mind on a substance level. And so it's useful to know. The request for production, I'm going to ask for medical records or bills, photographs documenting the injury, and police reports, because if they got a lot of it, I want to know prior to trial, because I'm going to review it with my client and say, look, it looks like there was certainly some evidence that you were beaten on her during this relationship. But if they can't produce any of it, it's absence of evidence is not evidence of absence, but it's certainly better than evidence. So the fact that they don't have these documents is useful, or the fact that they do, it's not helpful in your case, but you better learn about it. It's useful to know if the other side is holding the 14, so to speak. You may think they're holding, pair of 7s, but they've got injuries showing black eyes, police reports, medical bills. That's pretty solid evidence. And then requests for admissions. I'm not necessarily going to ask these if they're accurate, and if I know that the domestic violence took place. But if there's a big reason to dispute it, admit or deny that you never contacted law enforcement about any physical abuse, domestic violence the defendant committed upon you. If they admit that, then that goes to, I can use that, that's a useful admission for trial. If they deny it and they can't produce any of these incident reports, then it attacks their credibility. So again, these are being used to either gain a useful admission or attack credibility. But obviously, for example, if I already know that there's numerous police reports, I'm not going to ask that request to admit. And finally, think of discovery as a way of encouraging settlement. For example, oftentimes I will issue discovery in a case along with a settlement proposal. And I'll tell the other side, you can accept the proposal or you can answer the discovery. But if you accept the proposal, you don't have to answer the discovery. And that's going to prompt the other attorney to bring their client to review the discovery and review the proposal and discuss budgets. It's going to take some money for them to answer discovery, and the answering discovery is going to have some uncomfortableness to it if you've drafted it correctly. And so, it might force the other party to think about settlement perhaps earlier than they might want to think about settlement, but it will help your client then, because you don't spend a lot of money on discovery, you don't spend a lot of money on both doing discovery and discovery is often also a useful tool to telegraph to the opposing attorney, assuming the opposing attorney is paying attention as to what the weaknesses are in their case and what you would be coming at them at a trial. So they see this discovery, they see I have to answer now a question, admit or deny that you smoked marijuana with the kid. I got to answer that, it's not going to help my case. Maybe I need to look at this settlement proposal. Now, it doesn't mean they're going to necessarily accept the settlement proposal, but typically I find that attorneys will start engaging in negotiations at that point rather than answering discovery. And my client will often ask, well, why are we issuing discovery if we're hoping to get a settlement? But typically it'll only take me an hour tops to draft discovery along with the proposal. And that hour I find is very useful. It just naturally gets the other party to think realistically about settlement rather than sticking to their position. So think of discovery as a tool to encourage settlement, because it often can be that. I will often couple my discovery responses, my settlement proposal with discovery requests. So we're going to take a break now to 10:45, and if you have any questions, feel free to come on up at the break.